We've got about 5 minutes left in the Q&A, so we have some questions. Yes, sir, right here.
This is really addressed to the panel against the motion. But what seems to be missing in your argument is a lack of addressing the nature of the threat. The threat, it seems to me, is that our terrorists today have technology too, and they have a technology that affects the existential nature of our society. And don't you believe that there should be at least some moderation in your point of view and flexibility relative to the threat that you're confronting? So that it's one thing to protect individual rights when a relatively limited threat exists. But when you're talking about an existential threat to the nation, to millions of people, don't you have to suspend, at the very least, this firm, rigorous approach? That's my question.
The threat to our nation at the time the Bill of Rights was drawn up and adopted by this nation was far greater than the threats we face today, I dare say. We faced at the time the very protections against unlimited government intrusion that are embodied, for example, in the Fourth Amendment, were such that the very existence of our nation was clearly threatened by the greatest military power on the face of the earth. Not a handful of cells, but a military power that could wipe us off the face of the earth as a sovereign nation, that is Great Britain. In the face of that overwhelming threat, our founding fathers understood that the answer to your question is no. Government should not, even facing the most dire threat to this nation, allow, or the people should not allow government, even facing that level of threat, to invade their privacy without a sufficient reason. And indeed, there is great flexibility that you mentioned already embodied in the Foreign Intelligence Surveillance Act. Great flexibility. There is tremendous flexibility built into the Patriot Act already. And yet the other side is arguing, by the terms of the question here this evening, is that insufficient? And should government have essentially unfettered power? And the answer to that should be no, the same as it was no in the 18th century when these very precious mechanisms for guaranteeing our inherent rights were crafted.
John, I think I'd like you to respond to that because you were instrumental in crafting the administration's legal opinion on that very point about whether the president could go beyond the Foreign Intelligence Surveillance Court and without any warrants at all eavesdrop not only on the foreign agents but on people inside the United States.
There are two things going on here. First of all, with the Patriot Act, which is not the focus of your question, I think it's the focus of your question, there is a system of secret courts and secret evidence that issues secret warrants for secret wiretaps. That system was created in 1978. The Patriot Act amended some of those provisions, but the basic structure is one that we have been happy to live with for almost 30 years. And so this claim that the Patriot Act was this huge revolution, I think, is mistaken. The second thing I would say is, in terms of the ability of the president to go beyond the Patriot Act, that's based on history. As I said, every president, and as Andrew said, every president from Woodrow Wilson on used exactly those same authorities when confronted by a foreign attack or a foreign threat. We're not arguing here for unfettered power. We're not arguing that these powers ought to be used in peacetime. We're not arguing that these powers ought to be used to catch common criminals. I actually personally don't think any evidence from those surveillance programs should be entered into court in any kind of criminal prosecution. They are there to try to prevent a future attack. And it seems, and this is really David's key point, it seems weird, right? If you're outside the United States and you're a terrorist, the NSA has unlimited ability to track you. You don't have to go to a court and get a warrant to surveil Osama bin Laden. If Osama bin Laden were to move to the United States, then a whole system of court-ordered procedures are required under the other side's framework. That is a perverse and exactly reverse incentive.
Let's not exaggerate court-ordered procedures from a court that has almost never denied anything the government has asked for in a secret proceedings, which also has the power, and the government has the power to engage in surveillance before getting a court order. But John, the most striking thing in your answer was your statement that these, to quote John Ashcroft, had a different view. He described the Patriot Act as giving the government sweeping new surveillance powers. That was his exact quote.
I'm
I
not
can give you a
defending
citation.
Ashcroft
Okay.
today.
Well, he had a different view of the
But
scope
did you
of
work
this
for
law.
him?
And
I did, but it wasn't pleasant.
and
And I certainly would never have been promoted to speechwriting.
And you know that the government has shown that it has used most of those sweeping new powers in ordinary criminal cases, fraud, gambling, drug crimes. I'm not condoning any of those crimes, but isn't it interesting to hear you say that you oppose the way it has mostly been used, in fact?
I don't think it's, the NSA wiretapping program has not been used to prosecute garden variety crime. I mean,
I'm talking about the Patriot Act. Remember, the NSA went
See, that's what I'm trying to make
around
clear.
and underneath the Patriot
Most of
Act.
you, I thought you all just said the Patriot Act was something, most of what you supported, some of what you didn't, but I thought we were talking about the NSA wiretapping program where there is a very clear distinction about what that evidence can be sought for. It's not to be used for criminal prosecutions, and as far as I know, it never has been used for criminal prosecutions.
We don't know what it's been used for because it's been entirely secret and the government has refused to tell us what it is.
Wow.
But we do know that the evidence from the national security letters has been used in ordinary criminal prosecutions. In fact, the Inspector General found that there had been at most 2 terrorism-related convictions, but about 30, which was out of 140,000 letters, only 30 other criminal convictions for crimes that had nothing to do with terrorism. I have to say, the gentleman earlier asked, would you give up nothing? I would make a deal with John. He says, give us this broad warrantless surveillance power, but we can only use it for intelligence and we can't introduce it in criminal prosecutions. I would take that deal. That's a deal that the Germans have struck. They allow broad intelligence powers, but it can't be used for prosecutions. And for me, that's an example of the thoughtful balancing of privacy and security that allows us to have both at the same time. But every time the administration has been presented with this deal, it has been completely adamant. It's refused to make those sensible trade-offs, and that's why you have to vote against their position.
Just about 20 seconds left, and it sounds on the face of it like a reasonable deal.
It's the law of the United States, it's long been the law of the United States, that if agents are searching for a legitimate reason, if they have lawful reason to be searching what they're searching, you can use that evidence even if it's not what they were looking for in the first place. Now, I'm not saying that it's not the possibility of a reasonable compromise, but the suggestion that it's an unreasonable position not to want to negotiate that is I just have to disagree with that.
Andrew, thank you very much, and that ends the discussion.